right, we'll call our next case then, which is ALLSTAR Cleaning Service Incorporated versus Ann and John GRINWIS. All right, you may want to let your colleague there get all set up.
I'm good, Your Honor.
Okay, you're good? All right, go ahead. Is 5 minutes all right on rebuttal?
Yes, Your Honor. Thank you.
Okay.
Thank you very much. And good morning. May it please the court. Dennis O'Connor for the appellant, ALLSTAR Cleaning. And I'm wondering, Judge Torpy, if sometimes an initial argument could be harmful. So,
Well,
this...
in this case, it
Yes.
went to the jury only on whether ALLSTAR was negligent for failure to warn or sufficiently advise Ms. GRINWIS of the waxing, correct?
Yes, Your Honor, that's precisely what was pled. That is precisely what was submitted to the jury. This jury, and the case took 4.5 days to try. There were anywhere from 12 to 15 witnesses, including medical witnesses. And I track the length of deliberations and any questions that arise during the deliberations. And this jury retired at 12:53 on a Friday afternoon. I don't remember whether lunch was ordered. Knowing the hospitality of the folks in Brevard County, I suspect it was. And they had a question at 2:15. And the question was as follows: please define negligence for failure to warn of a dangerous condition. And the trial court instructed the jury to revisit the jury instructions that were read to them about the definition of negligence and duty to warn. I told my client, as we went back outside to look out the window at the baseball facility as we waited, that if they have a verdict within 30 minutes, it means we win, because it means they haven't gotten past that first question. And sure enough, right at about the 30-minute mark, they had a verdict. And we felt very confident that we had won, because we knew they were still discussing and considering the very first question, that is, whether there was negligence.
Well, if Ms. GRINWIS was already aware of the fact that they were waxing and knew that the process of waxing could make the floor slippery.
Admittedly, she was aware.
Did you put on evidence about her knowledge?
Oh, yes.
Quite a bit?
I can recount for you 10 separate instances when she was actually expressly told or would have seen or would have known. Forget about her own admissions that she knew that there would be water on the floor or something on the floor that would make the floor slippery.
Didn't she let the vendor in to the
She
building
did.
that morning?
Right, so yes.
Order to clean the floors?
She absolutely did, but it starts before that. It starts the day before, when there's an email from Mr. Aronella, the owner of the company, to a commander named Price telling him we're coming. And then there's an email from Commander Price to Sergeant, the supervisor, his name is Sergeant, telling him he's coming. This is a Saturday morning. It's unusual. The only people at the command center are these 4 or 5 employees, dispatch employees, 911 employees. This is on Babcock Street. The plaintiff herself, is the one who lets the crew, it's Mr. Aronella and Mr. Hodgkins, 2 of them, lets them in. They arrive, she lets them in, she sees the equipment, the trucks, the stripping equipment, the waxing equipment. She then, during the course of that morning, and this went on all morning, she took 3 cigarette breaks with them, 3. She knew exactly what they were doing. And
Did Mr. Aronella tell her that we are here to strip and wax the floors?
Yes.
According to his testimony.
Yes, sir. And at every phase of this process, so stripping and waxing takes a while. And stripping, by the way, it involves equipment, it involves chemicals. The equipment is loud. The equipment, and there's a drawing of the inside of this building in our brief. There's a window that you can see the hallway on the west side of the building. You hear the equipment. Frankly, you can smell the stripping chemicals. It's pungent.
Counsel, does the record indicate how many separate locations were being waxed that day?
Well, at the time of parts of the floor surface was carpeted, so that wouldn't have been waxed. Part was vinyl. It was the vinyl surface. So
I'm specifically referring to different parts of the building. Does the record reflect that they were working in one spot
No, sir.
all day? Or
No,
that
sir.
they were moving around?
So she falls on the south. If you
Well,
vision,
let me ask you this. I mean, she let him in. She knew they were working. It doesn't seem like there's any doubt about that. But how, where's the line? How is she supposed to know they're there all morning? How is she supposed to know, well, they're working in this spot right now, so I need to be careful?
So apart from her walking past these individuals and having been told, and in fact, she was warned. Miss Sanders and the other two ladies in the communication center, they were told, and Mr. Arenella, he testified before every phase of this process. He went into that room and said, I am about to do this now. Here are your instructions.
Did he also tell them, though, which part of the building he would be doing that in?
I don't think the record identifies a specific point in the building, just that it was being done.
Is it possible that they were working in an area that she didn't realize they had gotten to yet?
No, sir. That
Why
she
not?
had to have seen, on her way out, she had to have seen them in the area. On her way back in, she walked right past Mr. Arenella, and this is all on video, and we have still photos. And videotapes don't deceive. Still photos don't deceive. These are integral to the record. If you look at the video and look at the stills, you watch as she walks back in. She is carrying, and she's a grown adult. She's got Long John Silver's food. She's got bags on her arm. She's got a carrying tray with drinks. She's got a key fob. She's got a purse. Look at the video if you have a chance. Look at her eyes. Look where she's looking. Look at what she walks right by. She walked by a 5-gallon red bucket, more red than the red color of that flag over your left shoulder. She walked right by a scraping stick that was leaning against the wall. 40% of this aisle was obstructed by those two pieces of equipment. And coming from the north to the south was Mr. Hodgkins with a bucket that had the warnings on it, and there were other buckets within the property with warnings on it, and other signs set up with warnings on it.
Were there any signs in that location at the time she fell?
There was not a sign at that location at the time. A specific wet floor sign, there was not. There was a big red bucket, there was a stick. Mr. Hodgkins was on his way to that area with the bucket that has the sign on it. And had she looked to her right, and had she taken a carpeted route, because to her immediate right as she walked in, she could have gone straight north in this rectangle. It was carpeted. She would have seen Mr. Hodgkins coming towards her with that bucket. So Mr. Arenella, within 30 minutes or so before this happened, knocks on the door. They're now finished with the stripping. They're now finished with the prep for the waxing, which is the final phase. This has gone on for 3 hours. Noise, smell, knocking on the door, cigarette breaks. He said this: the floor is completely stripped. It's been rinsed, it's dried. If anybody has to go to their locker or would like to use the restrooms besides the comm center, now is the time to do it. We are going to be starting our waxing process in about 10 minutes. And once we start our waxing, the floor will be completely off limits for 3 to 4 hours. So, that was told to her. Ms. Sanders said everybody heard it in the discharge center, or the dispatch center. It reminds me of the expression, we're going to tell her what we're going to tell her. We tell her, and then we're going to remind her what we told her. Has our jurisprudential bar been lowered to that point where we have to take a grown adult by the hand, having been warned time and again?
Does the record show that she was in the room when that warning?
Yes. Ms. Sanders said everybody was in the room. Ms. GRINWIS didn't recall what was said, but she acknowledged that he came into the room once, and I think maybe more than once. Ms. Sanders said yes, everybody, he said it loud enough for everyone. for everyone to hear.
And that was before she left to pick up lunch?
Yes, sir. Yes, Your Honor. It was probably it was right after, this is around noontime, give or take. It was right after Mr. Arenella knocked on the door and said, we're getting ready to wax, which is the final step of this process. Then she exits to go get lunch for the group and herself, and she comes back 15 minutes later, and they had applied the wax.
There was another path she could have taken where she wouldn't have had to go over the waxed floor.
Sure. As you enter that southeast corner, that entrance, where all the trucks and the equipment in this is a staging area for a major floor project. She could have made a quick right. That's carpeted.
When you say 15 minutes, does the record actually demonstrate that it was 15 minutes?
It's 15 to 20 from the time.
After the warning was given?
It was a little bit longer than that, Judge. It was 15 to 20 minutes from the time she left until she returned with the food. It may have been, and I'll yield to the record.
Timestamp on the video in terms
It's
of
all-
when she
yeah.
left and when she got back.
We had a strict time. We had it all time stamped on the video. We knew exactly. It was 12:28, 12. But it was. I'm recollecting maybe 30 minutes, 20 to 30 minutes. It was shortly after Mr. Arenella made the announcement to her. So she admits that she knew what they were doing. She admits that the vinyl floors with liquid on it would be wet and slippery. She leaves, she comes back, and if you watch that video, which is not deceptive, and it's not something extraneous to the record, you watch her walk in with a purpose, and she just wasn't paying attention to where she was going. And it gets a little bit better. I mean, we try these cases for 5 days. We spend tens of thousands of dollars putting on these trials. And then the trial court just didn't like this verdict, just disapproved of the verdict, and became a seventh juror. That's what he did. And so you watch it unfold. She falls. You see Mr. Arenella and Mr. Hodgkin come up to her. You see them conversing. There's no audio, but you see them conversing. And they both testified that she said, in effect, and I'll paraphrase, I feel so stupid. I knew you were waxing the floors. This is my fault. And the jury heard that too. So as we count the number of ways that she knew or should have known, there was this memo. She let them in. She's smoking with them 3 times. She's walking past equipment. She hears equipment. She can see right outside her window. As she comes back in.
Sanders or Saunders or something?
Ashley Sanders was her colleague.
What about the workers' compensation questions, comments also
sure. Yeah.
have come up in terms of the judge
Yeah,
granting
so,
a new trial?
right, so, jurors are not robotic, and ever since, the day and age of inviting jurors to ask questions, if a juror asking a question is grounds for appellate review, you better triple your staff, because I can tell you it happens in every case now. And just because a juror thinks about workers' compensation doesn't mean that he or she's thinking about something extraneous to the record. It's not the case at all. In fact, the questions were answered as they were answered properly and by agreement of the parties. In the minor versus...
Plaintiff moved for a mistrial?
Never. And we've raised that in our brief. In the Minor versus McKesson case, which we cite, I know about that case. I happen to have tried that case. I remember that case. The jury went out, and then they started asking a series of questions about attorney's fees and can we do this with the medical bills? And Judge Holder handled those questions and tried to ameliorate sort of the issues that arose. And you could hear the commotion back there. We're sitting in a courtroom. It's the old courthouse in Tampa, downtown. You can hear the commotion. They're yelling, they're laughing, they're yelling, they're screaming. And then they enter the courtroom, and they throw the foreperson throws the verdict at the bailiff. And the judge took the verdict away. It was a verdict for the plaintiff. That was reversed because you assume the jury gets it right. There's a presumption. The Minor case talks about the presumption that the jury gets it right. And there's nothing that they considered that was extraneous to the verdict. And that
Counsel,
Tampa... Yes.
well, our standard of review here, we're supposed to give the trial court
Right.
great deference, correct?
Yes, sir.
And is it appropriate for the trial court to, having seen the testimony, which we can't see, to actually evaluate the credibility of the witnesses and their demeanor and things when
Sure.
when ruling on a motion for new trial?
Sure, did he? He didn't. If you read his order, he says nothing, there's no rationale given. There's no explanation given. All of the tradition in this court is very rich in terms of reversing orders granting new trials based upon manifest weight of the evidence. The Hernandez case, the Ford case, Judge Dalton's case addresses that. But what the thread through all of those decisions is the trial courts go to great pains to explain why. They go to, even in the Cloud case, the trial court went to great lengths to explain why the evidence, how the accident happened, could not support the verdict. In this order, here's what the trial judge says. Based upon the testimony presented at the trial, showed at least some degree of negligence. That's what he said. So what does that sound like? That sounds like a comment made by a juror in a jury room talking about the evidence, right? That's a fact finder statement. What does that mean? How can he step down from the bench and go into the jury room? How can he do that? Does he comment on the credibility of Mr. Arenella, Ms. Sanders, Mr. Hodgkins, any of the doctors? No. Does he say there's something extraneous to the evidence? No. Does he say the jury was somehow deceived? No. What does he say? He says nothing other than, I'm the seventh juror, I'm nullifying this verdict, I don't agree with it. And in the Hernandez case, that's what Judge Thorpe did, and Judge Thorpe was reversed. But even in Hernandez, there was findings, there was a rationale provided by Judge Thorpe. That's not even done here. It's just, there's got to be some degree of negligence. Had the defense lost, do you think it would have been proper for this judge to grant a new trial because the jury didn't find some degree of comparative negligence? Of course not. It's not his prerogative. It's not the province of a judge to become a
Into
juror.
your rebuttal time. You want to save the rest?
I would save the rest for my rebuttal. Thank you very much. Your Honor, we would encourage the court to reverse the order granting the new trial and reinstate for entry of final judgment. Thank you.
Good morning. May it please the court. Your Honor, the facts of this case that are clearly not in conflict are...
Go ahead and identify yourself, counsel.
Sorry, Attorney Robert Hogue for the plaintiffs in the underlying case, Mr. and Ms. GRINWIS. Ms. GRINWIS was a 911 operator. Her staff that was with her in that room in the communications center, what happened prior to the day of this fall is of no consequence because the record is quite clear that nobody knew what ALLSTAR Cleaning would be doing in the room that day. Now, at 7 in the morning, they buzzed to come into this police facility. It was the Melbourne Police Station. They buzzed, none of the employees, and none of this is in dispute, know why ALLSTAR Cleaning is there. Ms. GRINWIS goes to let them into the building. According to Mr. Arenella, he says, it's 7 in the morning, we're here to clean and wax the floors. Now, my client, and it's undisputed, goes back to her job as a 911 operator, not only a 911 operator, but a ComTech 3. So it's...
Why did the judge grant a new trial?
Because, Your Honor, at the very minimum, the surveillance in this video shows that the defendant did not make the very most basic warning as to wet a floor and put a caution sign out. Mr. Aaron...
Warnings does a person have to get before they are aware of the situation?
There's no record evidence that Ms. GRINWIS disputes that she was told that the floor was being waxed.
Well, sir, there's a difference between her disputing and no record evidence.
Yes, Your Honor.
You'll have to agree that Mr. Arenella testified when she buzzed them in, he told her, we're here to wash and wax the floors, right?
He testifies to that, yes.
And he testifies, and what's the other fellow's name, Hodgkins or something like that, that once she fell, and I know she disputes, she said she felt stupid for falling, period, basically. The two ALLSTAR guys are saying she felt stupid or dumb or whatever the word was for falling because I knew you were here to wash and wax the floors. And to clarify, as thorough as Mr. O'Connor or whoever was trying the case with him, said, did she use the word, I knew you were here to wax? And that witness said, yes, that's what she said. So you have that kind of information. If Hodgkins ducked in and told them they were going to wax, Arenella ducked in and told them they were going to wax, he told them when they got there, her supervisor told them, she took 3 smoke breaks and walked by them. One time, Saunders went to get her coat, and she was going for a smoke break, and they were walking carefully. if you take all those in the light favorable to the defense, she's been warned repeatedly, hasn't she?
According
Made aware.
according to the defense's argument, Your Honor, but Ms. Grinwis does not, she denies being
No,
told.
not according to their argument, according to the record evidence.
Ms. Sanders testified that she did not know what they were doing in the building that day, and she did not know whether or not Ms. Grinwis heard any of those warnings.
The jury had the prerogative of believing the evidence that the defense put on, didn't they?
Excuse me, Your Honor?
Could not the jury have discredited your client's testimony in favor of the testimony of the defense witnesses?
They could.
Isn't that the function of the jury?
It is, Your Honor.
Unless the trial judge explains to us that the defense evidence was not credible for some reason that he observed, and explains that to us, how are we to affirm a trial judge's order that just sets aside a jury verdict?
Well, Your Honor, the argument is that the manifest weight is such that to find no liability.
What does that mean, manifest weight of the evidence?
The weight and thrust of the evidence suggests that there's at least 1% liability. I would argue, Your Honor, that the surveillance alone establishes that. This Mr. Aronella, the president for the defendant, puts wax on a floor, abandons that floor, puts no sign out, and then as my client is walking in, walks right past her and makes no warning whatsoever.
She was so focused in on what she was doing, she didn't even know she passed him until she saw the video. She didn't know the red bucket was there until she saw the video.
She had no knowledge that there was even any wax on the floor. His allegations is that he told her at 7 in the morning. And then he further alleges that he warned the room of...
All those are great for final argument. The manifest weight test is it's got to be clear and basically indisputable. Here you have a dispute. I mean, the case could have gone either way. I grant you, and I think both of you guys being out in the hall, as he talked about waiting for the verdict, could have gone either way. Could have been a verdict 100% one way, 100% the other way as it was here, or something in between. But you had conflicting testimony. And here in our Ford Motor Company case, don't we say that if you got two witnesses conflicting on the point, you've got a conflict in the evidence and it can't be against the manifest weight of the evidence?
But, Your Honor, I would argue that there are no conflicts of the evidence in this case. Ms. Grinwis doesn't deny what the...
Well, I don't know how you can say that. I honestly don't know how you can say that there's no conflicts in the evidence.
They say...
You just a few minutes ago invited us to disregard the testimony of the defense witnesses in favor of what your client said. I'm just not following.
ALLSTAR has not established that she actually heard it, or there's the alleged warning was at 7 in the morning.
Even if that's the case, is that the standard? I mean, how, does the defendant, at a trial have to prove that they not only gave notice, but that the plaintiff heard the notice and saw the notice?
Mr. Aronella alleges that he gave warning at 7 in the morning. There's no allegation.
He testified under oath.
Excuse me, Your Honor?
He doesn't allege it. He testified under oath.
He testified
You
that
can believe him or not, and the jury could believe him or not.
he made no testimony that he specifically warned Ms. Grinwis after that first occasion at 7 in the morning. So for almost...
Saunders talk about the fact that somebody came in, everybody was in the room when somebody came in, and then at page 452 of the transcript, which I know doesn't quite match up with the record page, that she and Ms. Grinwis were walking out, and Ms. Sanders says, I just walked very carefully. Looked like the floors were still wet, so I walked carefully. Why did you walk carefully? I didn't want to fall. They looked wet. And Ms. Grinwis was with you? Yes, sir. Did she walk carefully? Yes, sir. And then you've got Mr. Hodgkins, Mr. Aronella, repeating what she said about she knew, she felt stupid, because she knew they were waxing the floor. Now, I admit she denies saying that she knew they were waxing the floor in terms of what she said after the fall, but the jury could hear that. If the jury believed that testimony, then she had been warned at the buzz-in, warned by Hodgkin sticking his head in, warned by Aronella sticking his head in, warned or made aware. It's not really warned. You don't have to go, hey, look out. You have to advise somebody what's going on, right? That's really what the warning is to make them aware.
Yes,
Okay?
Your Honor.
Okay, and if she walked down the hall 3 times, once with Ms. Saunders being careful, you know, there's evidence there that she was warned. Whether it was enough or not is a jury question, correct?
Yes, Your Honor. This is a large building, and we're talking about a 5-hour period of time. There are no allegations that she was warned as she walked into that building. The best person with that knowledge was Robert Aronella, and he admits that he had other things on his mind. He also admits that he could have put a sign there and that he had many of them, but did not put one. There's 5 hours
The
of time
evidence is there
here.
that she would have seen that if she didn't see a man in a red bucket. I mean, you're asking the jury to speculate that had it been there, she would have seen it?
Ms. Grinwis testifies to having worked in that building for years in seeing caution signs in the hallway with a mop bucket placed across, or a mop stick placed across a yellow mop bucket, and that was not there at that time.
How long was the floor wet without a sign? How long are we talking? Does the
There was
record show
never a
that?
sign in this entryway or hallway. So
How long was the floor wet before your client slipped and injured?
roughly 17, 18 minutes. She left on a dry floor at 12:22. She came back at 12:38 to a wet floor
That
with
doesn't
no
demonstrate
sign.
when the floor became wet, correct?
The surveillance indicates that about 12:30 is when they came in. You see them come into the hallway, apply wax to the floor, and work their way backwards out of the way of their surveillance and leave no caution sign, no barricade in that hallway.
And how long was that? But from the time they left to the time of the fall? Based on the record.
About 16 minutes that they left that hallway abandoned. And then at the time Mr. Aronella was walking, he walked from an adjacent hallway to exit the southeast entrance. At the same time, Ms. Grinwis comes in, walks right past him to this hallway that he has left no sign in, and he says nothing because he has other things on his mind.
And wasn't your client asked, had you seen it, meaning that red bucket, would you have known to be careful? If I had paid attention to exactly what it was, sure.
Her test,
If she had seen a red bucket, she says, and known it was a red bucket for the mopping and waxing or whatever, and it doesn't have to be wax, she was discussing in her cross-examination, if it had just been mopping vinyl floor, that can be slippery, right? So
Yes,
she
Your
knew.
Honor.
She's an adult, she's been in this situation before.
she
How
also...
many times does she have to be made aware that they're mopping the floor?
She also testified that she had no idea what the bucket was in looking at it.
She
So
didn't see it.
it did not catch her eye because she did not know what it was, according to her testimony. She had no clue what the bucket was. It could have
See
been
a full-grown man with a cleaning shirt on.
walking past her. Your Honor, plaintiff would argue that that's an indication that all's clear, as he allegedly warned the group some 16 minutes prior. Hallway's clear, do what you have to do. He walks by her, says nothing, pretty good indication that there is no danger, makes no warning at all to Miss Grinwis. He was in the best position of anyone in this world to say, stop. I put wax on the floor while you were gone. He says nothing, and the jury finds zero liability to this man. Zero. In the most...
What case do you have where somebody has been repeatedly made aware of it, that they find, as a matter of law, that a defendant's negligent for not warning one more time right before the incident? What's the name of that case?
Your Honor, I don't have that case. I would
Doesn't
argue...
exist, does it?
Your Honor, I don't know.
If it existed, you'd be sharing it with us, wouldn't
I
you?
would.
It'd be in your brief, wouldn't it?
It would.
Right.
Any other,
Anything else?
on the jury issue, the juror questions?
Go ahead.
Your Honor, Ms. Grinwis, our position is that this 4 questions, there were 4 jurors, 4 different jurors asked questions, all of which the answer was workers' compensation, and 3 of these questions were asked on the morning before closing arguments.
Ever try car wreck cases?
Yes, Your Honor.
have you ever had a car wreck case yet where somebody didn't ask, did the cop give the plaintiff or the defendant a ticket?
I have, Your Honor.
But you've also had them ask that question repeatedly, haven't you?
Yes.
And that really goes to liability, doesn't it? At least in the juror's mind, that could go to liability. What'd the cop think? Who was at fault?
Well, Your Honor,
Here we got workers' comp, which to me goes more to damages, really, doesn't it? If anything?
well, Your Honor, there was also in the last question, one of the questions that morning, it said, in regards to settlement, and then first part of the question was, why is this not an OSHA recordable? That has nothing to do with the verdict. Why is this not covered under
I
long?
agree it doesn't have anything to do with the verdict. Whether it's OSHA or somebody's wondering about OSHA, how does that mean it's somebody's liable or not?
Your Honor, I would argue under the Tampa Sands case that it suggests a jury with an improper motive. You know, multiple questions from multiple different jurors asking about workers' compensation, 3 of which coming on the morning before closing
And
arguments.
the questions were so terrible, you moved for mistrial, right?
There was no evidence of irregularity. It's not as though
Did you seek to interview the jurors?
we did,
And it was denied?
and it was denied.
It's not an issue on appeal, right? On cross appeal. You didn't bring cross appeal on that, right?
No.
And the jury was polled whether it was their verdict?
Yes, Your Honor.
You know, and again, I understand that the work comp questions had nothing to do under our law and our evidence code and the common law about whether or not this was a proper warning or a failure to warn, just like a question about OSHA doesn't have anything to do with whether it was a proper warning or sufficient warning. But how does that then show that they put aside all the instructions that they swore to follow and rendered an improper verdict? We can't tell from the judge's order. I mean, if you can shed some light on that, that may be helpful, but
Well, Your Honor, there was no evidence that they were searching the internet about OSHA or had some knowledge of some settlement, but there's just so many questions all pointing to one issue that I would argue, as in the Tampa Sands case, it suggests a juror with an improper motive. Thank you. Nothing further.
All right. Thank you. All right. Do you feel compelled to give any rebuttal, Mr. O'Connor?
all right, thank you very much. But before we recess, is there anybody here on the 10 o'clock case? You are? Okay, fine.
Are you counsel for the appellee? All right. The court has been informed that counsel for the appellant is not going to appear because she inadvertently miscalendared the oral argument. So she has waived appearance at oral argument today. So are you here with your clients, or are your clients not here, counsel?
My clients are not present. I do have another attorney from my office, Heather Kalinsky, that was
Okay.
going to be joining me.
If you'll give us just a minute to caucus, we'll let you know whether we're going to allow you to argue or whether we're going to dispense with oral argument in light of the appellant's counsel's announcement that she's not going to appear. So just give us a minute to caucus, and we'll give you an answer to that, all right?
And we'll come back and give you an answer, then after that, we'll meet whoever'd like to stay out of the rain and have coffee. So we'll be in recess for just a moment. So if you'll stand by, counsel, we'll be back with you.